Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, coming to you guys today with a Chrisean Court Case Overview and a brief update and a surprise message at the end. This video is by request. I have had a lot of subscribers comment that they are confused. They don't know what's going on because this is being said, so on and so forth. The only thing that I can do is go over everything. I can explain, and what you do with that information is what you do with that information. Just like I do my GED and adult learners and notary signing agent learners, I provide you with the source and the information. How you perceive it or how you interpret it, that's on your own. First and foremost, I do want to go over the criminal and civil, uh, the difference between those two, because there is a lot of confusion. There are people out here that are thinking that they are going to go to jail if they miss some type of hearing when it comes to the courts, and that's not the case. I want to show you guys the process so that way you can understand this process no matter whose court case you are following. Now, this is for the state. When it comes to federal, I think I might cover that when I do Diddy this week. But without further ado, let's get into it and talk about the difference between the civil and the criminal court cases. Now, with the civil cases, when a lawsuit is filed, okay, it has to be served to the defendant or the respondent. With that being said, a citation has to be created by the district or county clerk's office, and a copy of the filed petition is with it, and it will be sent either to a process server, the sheriff, or the constable. Once they have received that and they have served it, the constable, sheriff, or the process server has to file what's called proof of service or a return of service to the court within a certain time frame. Failure to do so would be on them. Service is probably the most important step in a civil litigation, because if the other party is not aware that they have been sued, then you have a fighting chance to get whatever it is dismissed. So that's why service is important. I've heard a lot of things about, well, Chrisean was served at a football game. She wasn't. Let me tell y'all something. I have served people at a restaurant, at their home, at their place of business, wherever the case may be. It does not have to be your residence. If we have tried multiple times to serve you at your residence and you're not there, I'm going to serve you where you work. If that doesn't work out, and we may have a PI and they say, well, we see this individual at this location all the time, I'm going to serve you there. But what happens is the court has to amend the citation, right, to have that particular service address. So if I see, now I'm not saying for me, but if I see you going to church on Sunday at this location, then, but I'm pretty sure we will never do that. I should say like the mall. If I see you going to the mall every morning to do your little 2-mile walk, right? I am going to have the court clerk amend the citation to put that address, and then we can go ahead and serve you there. But Sometimes that's not even necessary. It's just with the process server. And the process servers usually have the same database as us, paralegals or attorneys have. And we could just look at the last known address and we say, okay, try this address. If that doesn't work and we see, okay, we have a work address, try that address. So it doesn't matter where you are, you can be served anywhere. So just be mindful of that. Now, once you are served, you have a certain amount of days from the day that you were served to file a response to that lawsuit. If you do not file in a timely manner within that time frame, the other party can go ahead and file a motion for default judgment. And that's a whole nother rabbit hole I can go down. But in the event that they do, then the case goes on. So here we have lawsuit, complaint served, and then defendant files. Now, one thing I do want to tell you guys is that mediation is requires the presence of both the defendant and the plaintiff. That is not something that can be missed. Now, just because either or does not show up, that does not mean that they're going to go to jail. Mediation can happen at any time during that process. It can happen as soon as they get served a copy of the lawsuit. Okay? Think about Diddy's case. As soon as Cassie filed, he settled. Why? Because they mediated before they did anything else. So mediation can happen at any time, but it does require the presence of both parties. Now, going down to the bottom, once the complaint is served and we're waiting on the defendant or the respondent to respond, we start our discovery phase. So that means I am drafting up questions that I need answered, documents that I am requesting, and I need you to answer to these admissions. I send that over. So once the complaint has been served and the defendant goes ahead and they file their answer, I can go ahead and issue out that written discovery for them to, answer these questions and produce these documents. And that is the same on the plaintiff sides. If the defendant hires a lawyer, then their attorney is going to draft written discovery for the plaintiff to answer, and so on and so forth. So that is how that works. Once they have answered the questions, provide certain documents, and answer to the admissions, then we move on to depositions. Depositions is just pretty much in front of a court reporter. Sometimes they are taped, but it has an opportunity for each counsel to depose each party, the plaintiff and the defendant. And they use all of this, including the written discovery, to build their case. After depositions, then we hire experts based off of, the type of case. We may have 1, 2, 3 experts, and it just can be for a number of things: a medical expert, a vocational expert, whatever the case may be. And then we'll have expert depositions. Like, okay, what is your expert, um, you know, acknowledgement on this matter? All right. So if we have an expert for the medical bills, can you please explain how, these medical bills and the medical what do I call it? Uh treatment was necessary. Then we'll have somebody that explain why the treatment that they has was necessary. Or if it's dealing with an expert for vocational reasons, as far as this person was injured and now they have a loss of income, and we'll have an expert for that. So there's an expert for pretty much everything that we use. But all of that is included in the discovery phase. Now, yes, this is the phase, but please understand that there are deadlines for each of these things. So how do you establish the deadlines? That's why you have case management conferences. So on a lot of these cases where you are seeing there's a case managed conference hearing, that is not for the parties. That is for the attorneys and the judge. So when you're going through the discovery phase, that's not something that's going to take for a whole year. No, written discovery, I need this answered in 30 days. When it comes to depositions, deposition needs to be held within 90 days. How did they come to these dates? At the case management conference hearing. So when you look at a court docket and you see case management conference, that simply means that either the councils have got together and says, okay, here's a timeline of when things are due, or the judge may say, okay, this is the timeline when things are due. One thing they always will schedule is a trial. So based off of the evidence, they have to and I say evidence based off of the discovery in the beginning, they have to submit a case management statement. So they pretty much have to come up with a informal schedule that they have to present at the case management conference. And the judge would be like, okay, I see that you put 50 days for written discovery. No, let's set the deadline for 30 days and everything. So they have to have a trial date set in order to schedule a deadline for the pretrial events. So if your case is scheduled in December of next year, that means between now and 30 days before that date, there are deadlines that each party or each attorney has to go through. All right. There is a cutoff time for discovery because at the end of the day, you have trial. So you have to have things done 30 days before trial. You have to have discovery done. You have to make sure you have your experts, already deposed and everything. If you had mediation, that is literally the last hope to settle your case before it goes to trial. After mediation, if they have not came to an agreement, then they're definitely going to trial. But there is going to be a hearing prior to trial to see if they are ready for trial, because if they aren't, then they can always push out that trial date. Okay, I hope I did not confuse anybody there. So this is the litigation process, and I'm going to show you guys as to why this is important. Now, don't freak out on this. Criminal cases are totally different. You do the crime, right? What happens? You get arrested, you get booked, and then the information is submitted to the court. Sometimes it is within a couple of hours, right? And then you may bail out and don't hear anything that happens on your case. You're like, dang, are they gonna file my case yet? Like, what's going on? Like, if you had a DWI or something, they won't file. The statute of limitations to file is 2 years. So within that 2 years, the state can file when they are ready. So you can bail out and not have a case with the state just yet, but do know that it's coming. But what happens to start that case, they file the information with the court, kind of like similar to a complaint. They file it with the court, they schedule a hearing, right? You go to the hearing, they either, they ask you if you have an attorney. Sometimes they will give you time to get an attorney. They will reset the case, or they will, get you a court appointed attorney. And sometimes they will reset the case so that way they can get familiarized with your case. But then, once you get that, you'll have plea negotiations, and then once you have plea negotiations, then you present that to the judge will make the final say, right? They'll say, okay, these charges is going to be dropped, or you're going to be charged with this, and then the next court hearing will be your sentencing, and so on and so forth. So it's not where somebody is filing a lawsuit, you having to serve somebody, so on and so forth. No, that's not how that works. The state files. The state makes the determination of whether they are going to file or not. If they do file, then it is scheduled for an arraignment or a hearing. You go before the judge and they, tell you what they need to tell you at that time. You negotiate with the attorneys in the state. You accept the plea, whether guilty, not guilty, no contest, whatever the case may be. And so and that's it. It is totally different than civil. Now, if you miss an arraignment, if you miss important court dates where the judge ordered you to come or appear, you're going to go to jail. And that's why they issue out bench warrants for failure to appear. So, civil cases, they don't have to appear. The only time a party has to appear is during depositions, mediation, and trial. That's all. Case management conference, they don't have to appear. But in a criminal case, you have to appear unless the judge says your appearance is not needed. All right? So I spent quite a few. If you don't understand, definitely reach out to me and comment. Otherwise, the information is on the internet. Just Google what's the difference between a civil case and a criminal case, and you will get your answer. So going to Chrisean's update. As you can see, she is still here. There's no release date. Oklahoma still has a hold. All right, no release date, still a hold. Going over to this particular case, there are no new updates. The next court hearing, non-appearance hearing, is August 26, 2024. Her presence is not required. Why? Because only a report has to be submitted. The firearms prohibited relinquish report for her to relinquish any non-firearm weapon that she has in her possession. I spoke about that a while ago. I forgot which video. All right. So she's still there. She doesn't have any upcoming hearings. She only has to turn in a report by August 26th. Scrolling down to Oklahoma, and I'm going to refresh because I know I've been a while. Okay. Here are events. Now, as you can see, remember when we was going here and it had an attorney? She does not have an attorney because he withdrew from the case. Events, any hearings that are scheduled will show here, past or present or future. The only thing right here, the last thing we have is the tax intercept, but before that, the bench warrant was issued for failure to do community service, as well as the application to accelerate her probation. Her sentence. I'm sorry. The last entry on the docket was the motion and order from the attorney withdrawing from her case. The attorney did what he was hired to do, and that was to get her negotiate her plea, and he did just that. So his services is no longer needed. It's as simple as that. Okay. Moving on to, what is this? This is Aaron. I don't want to do Arizona. I'm going to do Maryland. Now, I'm going to, yeah, everybody can see this. Okay, so for Maryland, I'm pretty sure everybody has checked. This website does not like me. So as you can see, there is one case that is currently showing for Chrisean. The filing date was May 15th, 2020. 2020. This was filed prior to her charges for Oklahoma. This was prior to her accepting a plea in Oklahoma. So whatever is going on in this case has no effect on Oklahoma. So for this particular one, this is a warrant. She does have a warrant. Here's when the warrant was issued. And this is for the paraphernalia and the Mary Jane. So she does have a warrant. But this case was filed prior to Oklahoma. It has no merit or effect on Oklahoma. If it did, then she would also have a hold for Maryland, but she does not. The hold is only for Oklahoma because she violated her probation. Now, we are all wondering what happened to the Woah Vicky case. I have searched up and down this court docket and I could not find that case. What I am thinking is because the court has received so many responses, emails, calls regarding this case that they made the case confidential. And they can do that. They have the right to do that. Not everything has to be visible to the public. Now, has the case gone away? I don't know. I just feel that it is confidential at this moment because of everybody calling, emailing, so on and so forth. What I did do is a lot of people don't know that Janet was also charged. She was also charged in this. How do I know it's the right person? Well, first of all, Vicky did not know Janet's full name, so therefore she put Malone at the end. But if you see the complainant here, Victoria Waldrop, aka Vicky. So Janet does have a warrant out for her arrest for failure to appear in the case against Vicky. As for Chrisean, I don't know because her case is confidential. I hope everybody understand that. Going into Arizona. This is the Arizona case. As you can see, she received 2 citations, one for disorderly conduct, the other for criminal trespass, which was dismissed by the city attorney. So what I'm going to do, I'm going to take this citation and I am on Scottsdale, Arizona's website where you look at the parking tickets. I'm entering in the citation. And here we go. So she doesn't have any warrant by her name because normally if you're wanted, you will have a warrant signed by your name. This is a simple ticket. They issued her, they fined her. Here's count 1, disorderly conduct, $500 fine. Number 2, criminal trespass in 3rd degree. It was dismissed. Deposition date was on 8/22/2022, and that was 150. So he dismissed all of this. So all that she owed was $500. This is the total amount that's due on her case now because she ain't paying. It's in collections. So that's going on her credit report. This ain't, I'm going to jail because I didn't pay Arizona. It was a fine, in which is now in collections. Okay. This person, I don't know what she was doing. She filed the motion, But it was just a simple one. You missed whatever statute of limitations you had on this. That's for one. But two, they dropped the they dropped the trespass and just charged her with the disorderly conduct and said, "Here, pay a fine," and which she did not. See, traffic license suspended. That's all they did. They gave her a fine and suspended her license. Okay. Let's see. Now I want to bring up her civil cases. I pulled these from the docket yesterday, as you guys can see. This case was filed on, hopefully you guys can see that, on, was that October 26, 2023? These are all the people that she sued. Attorney information. All right, so we're reading this. This is the calendar information. There are 4 things on the calendar. So the March has passed. All right, so next hearing is on at 9 a.m. on July 31st. They're having a hearing for failure to file proof of service. Another for failure to file. I'm gonna go down and we're gonna look at that. So what this means is that the process server or the constable or the sheriff failed to file proof that they served the defendant or defendants. Okay? They are also having a case management conference hearing. Remember, we just talked about that. This is not something that the defendant nor the plaintiff has to appear. This is the attorneys and the judge actually scheduling out and setting deadlines for events. So a deadline to submit discovery, written discovery, a deadline to do depositions, a deadline to do mediations, a deadline to have your experts and have them turn in their reports. That's it. Now, looking at this, I'm just going to kind of go. All right. So she filed on the 26th. So all you see here, going from 26 on down, the complaint, the case management sheet, the cover sheet, the alternative, I call it the ADR packet. All right. Jury fees was posted on the 4th. Now it does show that we have proof of service. So that's 1, 2, 3. I'm not sure as to how many defendants was on this case, but I'm going to see. So we do have the proof of service here. So that means 1, 2, 3 defendants were served, and they indeed filed the proof of service on this date. Now, when they were served, we don't know. Okay. Then we have somebody post. Okay, so Zeus filed an answer on February 7th, posting the jury fees, and then MGP filed an answer on February 16th. Proof of service was filed on February 20th. Case management statement. So this is, I don't know why I did that. So the statement is pretty much the agreement between the attorneys as far as the deadlines of the case. That's all it is. Then what happened is she filed a request for entry of default judgment on March the 7th. And the only way that you can file, and they call it an entry of default judgment. I call it a motion for default judgment. But either way, the only way that you can file this is only if the defendant failed to answer during that 30-day period. So if they were served on November 1st, that means that they must have had their answer filed with the court within that 30 days from November 1st, 2023. If they filed it afterwards, then that's going to be a problem. And what I'm thinking, if I go back here, a proof of service was filed back in December, which means that in January they would have to had file their answers, but they filed their answers in February, which is an issue. Therefore, that's why they are having the hearing, right, to discuss whether or not they filed their answer in a timely manner. Because if you filed the proof of service on this date, that means their answer was due on this date. So there's some type of discrepancy. So they have to talk about it. But either way, they missed their deadline to file the answer, so they put in an entry to file for default judgment. And then let's see, another case management statement was entered. She re-entered another default judgment request on the 8th of March. Then they had a notice of remote appearance filed by MGP. So this is just saying that I am the attorney for this defendant. That does not mean that the defendant had to be present. MGP did not have to be present. It was just simply saying, I am entering in as attorney for this defendant. Case management conference minutes, let's see, 321. And then she entered another request for entry of default judgment on March 25th. I want to know who this attorney is because this is wild. Notice of ruling, then proof of personal service again on the 27th. Let's see, they had all right, and then it goes to the case management calendar. So that's all it was. So they initially had a case management conference on the 21st, but they ended up extending it because there's some information that they got to figure out. They have to figure out as to whether they are going to accept this motion for entry, or I say motion, the entry for default judgment, because not either the defendants did not answer or the defendants answer, but they answered after their expiration to answer. And this is for Lashala Irby. I don't even know. I think that's the hairstylist. I don't follow up with these folks. All right. Going on to Rama, who filed earlier this year. She filed on February 26th. Let's see, any hearings. So they had the order to show cause hearing and sanctions. Somebody is getting penalized because they didn't do what they were supposed to do. I believe that one was the failure to file the proof of service. So there is some type of discrepancy with that one. But once again, this is not something where Chrisean had to attend. Okay? This is a case management conference. Once again, that is just the judge and the attorneys setting deadlines for when pretrial things need to be done. They have an order to show cause hearing sanctions and another case management conference on September 24th, 2024. So whatever is going, I need to figure out why sanctions is being imposed on this. I need to. Let's see. The last thing was the minutes. So for here, here's the filing information. So February 26th, complaint was filed, ADR, packet, cover sheet. Case management conference was also scheduled on March the 1st, and I'm assuming it's usually scheduled days or months out. Let's see. On the 15th, notice of case reassignment and order for plaintiff, case management status, and then minute order. So here, it doesn't even show the summons or the citation. Hold up, let me go all the way down. All right, so yeah, so the summons was issued. So she filed the complaint on the 26th, and the summons was issued then. But it does not show that there's an answer filed. And I don't see a proof of service. Yep, there is no proof of service. And who's the defendants? So, Does 1 through 20, Rock, and Zeus. So, as of right now, it doesn't even show that they even were served. It does not show that their defendant was served. So they have to there's nothing really that they can do until Zeus, Chrisean, and really Chrisean and Zeus gets the lawsuit in their hand to give them an opportunity to respond. So on this case, once again, nobody has to show up because this is only between the attorneys and the judge. That's all. That's it. Nobody's going to jail for missing a conference, a case management conference hearing. That has nothing to do with the plaintiff nor the defendant. So I am closing all of this out. So I believe that is all. I just wanted to break down the difference between criminal and civil cases and run through her cases that she has, criminal and civil. If you are still lost or you have a question, I would advise for you to comment it and I will try my best to answer your questions. But that is all. There's not much, going on with Chrisean. We are just waiting patiently to see what Oklahoma is going to do. And that's all. Her civil cases are just civil cases. Um, if some, they need to serve her. And if she has been served on some cases, then all she needs to do is file an answer. Because if she doesn't file an answer, then it's automatically going to go into default. But it's not something that if she missed a civil case deposition or mediation, she's going to go to jail. It has no effect on her criminal cases. Maryland case with Woah Vicky, that has to be a confidential case because it's not pulling up. But the one that she does have a warrant, that was filed before she even accepted the Oklahoma plea. Therefore, it's not going to do anything. It doesn't affect her Oklahoma or her Los Angeles case in any way because Los Angeles and Oklahoma happened after this Maryland case. For Arizona, it is a fine. And the fine went to collections because she did not pay. That's it. Period. But thank you guys for tuning in. I do have some great news to share. I am really ecstatic on the amount of subscribers that I have. I have reached over 1,000 subscribers, and because of that and because of your views, I am now monetized. When I set goals, but I never expect for this to be one of my goals, only because this is a hobby, because I do have other obligations outside of YouTube. But I do appreciate each and every one of you that have been tuning in and supporting me. It's been awesome. I do have access to have memberships, so I am going to plan some things that I can have, members only content, exclusive content, especially when it comes to cases like Diddy and all this other, big name celebrities out there. So I do want to bring it to my members first before I share it to the public. So if you have an opportunity and you would like to join, I would love for you guys to join. I call it the jury peeps. It's probably a little cheesy, but we are all jury members when it comes to what's going on in America. But anywho's, thank you guys for tuning in. Don't forget to like, share, and subscribe. Until then, be blessed. I wish each and every one of you to have a productive rest of your week and have a blessed day and a blessed week. Until then, I'm out. Peace.